Pinellas County is now in session with the Honorable Judge Pamela Campbell presiding.
Good morning, everybody. Thank you.
Please seat. Thank you.
I think we're starting maybe a few minutes ahead of time, but that's okay. We have lots to accomplish. So, first of all, we're here on case number 12-012447, Law versus Gawker. We're here today for a case management conference. We have a number of different motions that you all have sent, and thank you so much for the defense for putting them all in a nice order. That really helped a lot. And I also want to talk about the plaintiff's emergency motion, some more argument on that from the July 1 hearing. And go over a couple of housekeeping things. You will notice that there's a new media order that went out last evening. I think I understand that all the different media received a copy of it. Unfortunately, at the conclusion of the last hearing, there was an issue in the hallway, and I just thought to get everybody on the right page. We've had an order that really sort of establishes ingress and egress for the parties. I would anticipate a separate order when it comes time to the trial, so that we will incorporate some information for the jurors, parties, any witnesses that come about, so that there would be mostly safe ingress and egress. While this case brings in a lot of more people to the courthouse, there are always a lot of other things that go on, especially on Wednesdays, so we want to make sure that everybody's respectful of all the other cases that are happening at the same time. I also, you all had mediation this week, so I would imagine since you're still here, it did not resolve. Is that correct?
Correct, Your Honor.
Correct, Your Honor. Okay. And Teresa had sent out a proposed trial order, which had the deadlines in there. I would, at some point today, like to discuss that trial order. We had adopted those deadlines pretty similar to the last one, but if somebody wants to change some of those deadlines, that's really what I want to discuss, so we can get everybody's input on that. And why don't we start first with a continuation of the July 1st, 2015 plaintiff's emergency motion. At that time, both sides presented their arguments. Both sides provided follow-up supplementary information that I have reviewed. I know that the defense wanted more time to argue the motion itself. There was so much in written material, I don't know how much more you can say without being duplicative, but I know that the plaintiff had supplied a proposed order from that, and I would like to go over some of those issues. I'm sure the defense has some issues.
I'm happy to do that, Your Honor. Before you get to that, I did want to just note that there are, my understanding is there's counsel for the needy interveners in the court, and if it made any difference in terms of the order, since they're present for the argument on the other matters.
Ms. Steele?
Your Honor, we would prefer to proceed in the court's suggested order.
Okay, thank you. I mean, I think they're all sort of interwoven. So, all right, so why don't we go ahead and start with that? Someone, did you want to begin?
I can be insured, Your Honor. Your Honor, I will try not to be repeating things that are either in our paper or that I was able to muster together on short notice the last time. Thank you, Your Honor. And I think what I'd like to do is to focus on three things. First, this is a unusual motion in the sense that it is not related to the issues that are directly in the complaint in the case, but is a tangential issue about whether or not an order of the court was violated. There is a body of case law that governs those circumstances, which we have cited in our papers, and I won't go over in detail here because I'm sure Your Honor has looked at them, other than to say that the plaintiff has not cited a single case of his own for the purposes of supporting the extraordinary relief that is being sought in this motion, and the law that does apply to these circumstances basically, not surprisingly, says before you go on this sort of expedition that you need to have some sort of showing that there has been a violation and that the party that you're going after was the one who violated that order. And the reason for that is pretty simple, which is otherwise it's easy for a party to make an accusation and then the other party is left proving a negative, which is where we find ourselves. We have said repeatedly as officers of the court that we have complied with your order, and yet here we are in a situation where the other side is saying to us, can you please prove a negative? The plaintiff here admits that the motion is not based on evidence or based on a showing, but is based on speculation. Their papers are replete with that admission. The argument that last time was that, and they've basically made 2 points, which are the second and third points that I'll try and address. One is they basically say, what's the harm, right? If they have nothing to hide, then just go ahead and do this investigation and it won't be a problem. And the second that they say is, we admit that there's all sorts of other people that could have provided these materials to the National Enquirer, but it must have been Gawker because they're the only ones with the motive and the opportunity to do it and to do it now. Let me address each of those points if I may, and at any time, Your Honor, if you have questions, please let me know and I'll try and respond. The first question is what's the harm? What essentially they're asking to have happen is that the court appoint a forensic representative, right, so that this person is a representative of the court to start rummaging through computer systems, cell phones, tablets, networks, cloud storage, backup tapes, and the like. And that is an extraordinary intrusion into a party's, and in this case we have 3 parties, into their computers and into their electronic life. And the Supreme Court recently decided a case where it said, look, we don't just willy-nilly start searching through people's electronic devices because it really, at this point in life, contains their whole existence. Here, we have an order that they've proposed, which is very different than what they asked for in the original motion. And the order is, if you look at what's covered by what they can look for, it's much broader than just saying we want to look for evidence to see whether there was a leak of materials. It asks for all sorts of things that go way beyond that, which is all communications concerning Mr. Balea, the lawsuit, Freedom of Information Act lawsuit. They've got a long list of search terms that you know, the term Hogan, the term Balea, anytime anybody's talking about this case, whether it had anything to do with the leak is now something that the court's expert is supposed to be allowed to look at. They've got, and then it goes back not just for a period in time when this National Enquirer story came, but it goes back to the initiation of litigation, and that's all laid out in the scope of inspection paragraph 4. Then you have a problem, which is that you have the court basically invading all manner of privileges, right? So that there's obviously attorney-client privilege, there's work product protected materials, there's material that's protected by the journalist privilege, there's material protected by spousal privilege, right? And the way the order's written, only the first 2 of those are allowed to be asserted at all if they're not asserted within 7 days. And we're talking about probably tens of thousands of documents to basically say, we're going to give you a disk with all of the stuff that we found. You go through it. You have 7 days to come up with a privilege log. That doesn't seem very reasonable.
What would you think would be a reasonable time frame?
I don't think any of this is reasonable, Your Honor, so I'm really not in a position to say that, and partly without knowing what the volume of the material is, it's really hard to answer that question. Then it says, and once you've disclosed it, if you don't put it on that log, it's waived. That obviously conflicts with the Florida rule about what to deal with materials, what to do with materials that are inadvertently disclosed. Then if you don't come to an agreement, you have to file a motion within 5 days, and that these timetables are just set up to impose incredible obstacles to asserting valid privileges.
I believe the timetables are, I think, probably unrealistic, so that's why I was asking what kind of time frame did you think that would be reasonable?
Yeah, and Your Honor, my point is not really about the timetables. My point is just that in the whole package of going through tens of thousands of documents, having the court rummage through the parties' computers, that's a problem. Then you have privileges that you're not allowed to assert, the journalist privilege, and when there's a federal statute, the Privacy Protection Act, 42 U.S.C. 2000 AA, which prohibits, as a matter of federal law, seizures by court officials or other state or local officials under federal law of protected news gathering material. So to the extent that any of this is covered by people who are, for example, reporters for Gawker, that is a violation of federal law. Then you can't assert the spousal privilege. So if somebody has talked to their spouse, too bad. Then the expert that's actually being appointed, so we're still on what's the harm of this, the expert that's appointed is their expert. This is an expert that they've used in the past in the case. You may recall, Your Honor, that we asked them for all their texts, and they said, here's all the texts, and then at some point much later in the case, they came and said, well, actually, we got an IT expert to go through I think it was Mr. Belay's cell phone, I'm not sure what else, and we found some other things. And that IT expert is the same expert that they're proposing to be the court-appointed expert. They used e-hounds for that.
Is there some other expert or forensic person that you would be familiar with, or that maybe Mr. Thomas would be familiar with in our area that you would?
I'm really not familiar with electronic forensics in this area, and we can maybe while they're speaking, I'll try and consult with Mr. Thomas, and I'm sure I have a couple of things in rebuttal to say. I'll try and answer that question. But the expert that they're saying that they want to use, then they say once they're done doing this court-appointed work, they can keep the materials until the end of the litigation, but then they can continue to be an expert for the plaintiff. That obviously is a significant problem. All right. The order refers new matters to Judge Case without the consent of the defendants. It authorizes unlimited third-party discovery, subpoenas to third parties. As Your Honor well knows, there's a Florida Rule of Civil Procedure that has a procedure for how to do that, which provides a timetable for objections by the other parties to the case. That's gone out the window in this order. Then you got contempt of court without a finding, right? If we find any violations, you shall be held in contempt of court. That's not consistent with how the rules work. So we have this extraordinary package, if you will, of relief that is onerous, to say the least, violates the rules, violates the federal statutes, violates the due process rights of the defendants. And so when they say, well, what's the harm? If they have nothing to hide, just go ahead and do this. There is a harm, right? They have reasons to not have the court or the court's expert or their expert going through their stuff. And so then we get to the point of, okay, well, this is the last point I wanted to make, which is that they say, well, we want to do this because it must be Gawker that did this, right? That's been their mantra in this set of papers. It's their mantra in their reply papers. In the opening papers, it was focused on Nick Denton primarily. The reply papers focused on A.J. Delario. And they concede that this is based on speculation. They concede that the text of what was actually published in the National Enquirer is different than any text that Gawker had. They don't match. They concede that there's a whole bunch of other people who had the same materials. There are news reports about this same subject dating back to 2012, and that those people are under no obligation not to disclose anything. But they somehow say, but it has to be Gawker. And they tie themselves up in knots to do this, Your Honor, right? So they say Nick Denton admitted that it was him when he wrote in his blog post that there's going to be a third act and it'll focus on Mr. Belaya's real secret, right? And they want to credit that sentence of his post. But then you say, well, wait a minute. The next passage says, but I don't have any inside information. There's a lot of stuff my lawyers aren't allowed to tell me, and I'm just reading the same press reports that everybody else is. And then he goes on at length to describe those press reports, right? He puts them in there. And the plaintiff says, I want to credit the first sentence, but I want to discount and ignore all the rest of this, right? And it's easy to speculate that it must have been Gawker if you're willing to sit and cherry pick the facts. But if you look at the whole facts, right? So then we say, okay, then the National Enquirer published this, and it has different text. And when we say, well, like, hey, the texts are different, and they say, well, maybe the National Enquirer altered the text to be able to protect Nick Denton as the source, right? And then you say, well, then the reporter for the National Enquirer tweeted and said it's not Gawker, right? And so we want to credit what he put in his article, and in fact they do credit it because right after that article came out, Mr. Boulay admitted that it was true and accurate. And they say, well, that part was true, but this tweet must be false, and how can we possibly trust the National Enquirer, even though they got the story right? So if you want to sort of say, I'm going to credit these facts over here, but I'm going to discount or ignore or wipe away these other facts, sure, it's easy to come up with a story where it says it must have been Gawker, right? And then they say, okay, well, it's not enough that we're going to pick and choose, we're going to turn the facts on their head. So then they've got an email from me where they say, I did not agree to the confidentiality of these audio tapes. And the audio tape is a tape that we're talking about, is a tape of the sting operation, which does not contain the text that's in the National Enquirer. So let's assume that I were to leak that text and I were to announce that I were leaking that text, it would not give the National Enquirer what they actually published. But the actual email that they're talking about says the exact opposite of what they say it says. It says on its face, I agree and have kept and will continue to keep confidential this audio recording. So now we have an email that says, I will keep this confidential, and they come and they tell you it says the exact opposite, that Berlin said, I will not keep it confidential. And so if you take the facts and you turn them on your head, of course you can come up with a situation where you say, here's some smoke that it must have been Gawker. So they're sort of left at this point with this theme, which is Gawker is the only one with the motive and opportunity to do this, right? You have, but if you were to go down that road and say, well, the only person, let's look at who had a motive to do this, who had the opportunity to do this, and who it makes sense that would do it now, right? That's sort of the point. Well, who would do it now? People knew this a long time ago. Why did they wait? But that's easy to do, right? Let me give you just a couple examples, if I could, Your Honor. You have Keith Davidson and his client, the extortionist and the lawyer for the extortionist and the client, right? They both had these videos, right? They had the transcripts. They got almost, they were in significant legal hock with the federal government, right? We're going to, they're going to get prosecuted. They came to Tampa, they got, they were arrested, they had to, hire lawyers to get themselves out, and now they're facing, as we know, another investigation by the Tampa Police Department, right? So they have motive, they have opportunity, they have a time frame. Why would they do it now? They're coming at, Mr. Boulay is coming after us, so let's get out in front of it and release these things. Now they say, okay, well, Mr. Davidson said on a particular date, here's a declaration that says I don't have this video in my possession any longer. It says nothing about his client. And, to be honest, here's again a cherry pick, right? Here's a guy they've spent 3 years saying this guy can't be trusted, he's an untrustworthy extortionist, but we trust this declaration, right? I don't know which is true, but it's one possibility. Another possibility is we filed a supplemental filing. It's filed under seal because it relates to things that came from the FBI FOIA case. But suffice it to say, without getting into the specifics, which we said in the cover, is that it's examples of other people who.
There's a whole list of other people that you've provided to me.
Right, but this is a specific supplemental filing of people who were investigated and are being investigated and have the same motives, right? Then you could say, well, maybe it was somebody, and I'm not saying this is true. I'm just saying if one were to sit and speculate like the plaintiff is, maybe it was somebody on the plaintiff's team, right? Lawyers and their paralegals and secretaries all got behind him thinking, this is an outrageous violation of Mr. Boulay's privacy. We're going to wear the white hats. We're going to bring take Gawker to task in court. We're going to bring them to their knees. We're going to do right. And then it turned out that in the case, you found out that actually Mr. Boulay wasn't so solicitous of his own privacy, and he talked about his sex life in graphic detail. And then you find out that the facts are sort of different, that actually he treated Heather Clem like a sexual plaything, and he didn't actually, and was not respectful of her. And then you find out that he went on this racist rant.
That maybe
Well, what I'm saying is, it's quite possible that a person who thought they were wearing the white hat looked at this and said, well, maybe I'm not wearing the white hat. Maybe I'm representing a pretty bad guy, and was hoping that that would come out at the trial. And then, Your Honor, it's true that it was without prejudice, and that was because the FBI documents hadn't been produced yet. But Your Honor's last ruling on this was that at least temporarily that was not going to be admitted. And they thought, well, maybe somebody ought to know the truth. You know, there's just three. I'm not saying, look, I'm not pointing fingers. I'm just saying, like, if one were to sit and I'm not coming in saying I want to investigate them. I'm just saying if you want to sit and speculate, that's the.
Written documents go through all that very thoroughly.
Right. So, well, why don't I stop? I assume they'll want to be heard on this. I will try and.
Sure, they are going to want to be heard on it. And I think, let me just say this, to get right to the chase. I reviewed everybody's documents. I've done some of my own independent research on electronic records in this new world that we're in with electronic records. And I realized in reviewing it all prior to the July 1st and after the July 1st that other than a verbal order that really never got condensed to writing to preserve the documents, there had not been a written order preserving anything. So I specifically made that order preserving electronic stored materials from dated August 6th, 2015, and in reviewing all of the supplemental materials that both sides have sent, I believe that the plaintiff had met a very heavy burden in, to some degree, granting their motion, not to the full extent that they have requested, and not to the full extent of the order that they have proposed, which why I was wanting you really to have an opportunity to tell me what different issues, if there's a different person that the plaintiffs have used, such as eHounds. I don't know all the different computer forensic people in town. I do know that eHounds is a common one that's used, that I've seen on a relatively regular basis. So, but if there's somebody else, Mr. Thomas, that you know or that you're familiar with, I'll certainly consider somebody else, especially if the plaintiff has used eHounds in this particular case. I don't think it would be appropriate to use eHounds as a designation from the court. I did also enter a different order on the order on plaintiff's emergency motion for clarification, which was dated September 23rd. I know that one of the objections to the proposed order by you, Mr. Berlin, was, I think it may have been this due date, but was that you had withdrawn your consent to Judge Case being the discovery magistrate. At the time that I received the different DVDs from the U.S. Attorney's Office, the stipulated protocol was still in place. There had been no pulling from the defense of the consent to Judge Case. So those DVDs are currently in a safe deposit box with Judge Case's name on it. So they are in a secure place. I don't consider those DVDs to be evidence. The court certainly wasn't going to keep them, and I didn't think they should be turned over to the clerk because it's not evidence. So I followed that protocol, and they have been sent to him under the protocol. I appreciate the fact that you have withdrawn your consent. I don't know, and I believe that the plaintiffs are correct in their rendition of the law, and that the time to withdraw the consent is in the beginning as opposed to at this point in the case. So we'll just have to cross that bridge later on. But that additional order that I did enter designates Judge Case. I did recognize that you had withdrawn your consent by the time I signed that order. I did see that, but I needed to know the history to that. So with that, is there anything in my comments that you want to comment to, or you want to hear from the plaintiff?
Well, let me, if I could, I think I'd like to circle back to the Judge Case issue in a little bit, but on the motion itself, I think this is what I would like to end with, Your Honor, and that's this. The documents we're talking about were, at your direction, designated attorney's eyes only, okay? And what the plaintiff is essentially, the plaintiff has given you a lot of smoke about Mr. Denton and his opening brief, and Mr. Delario in the reply brief. But before you get to Denton and Delario, these documents were given to us, to me, to Mr. Berry, to Mr. Sullivan, to Ms. Dietrich, Mr. Thomas, Ms. Fugate. And what is essentially being said in this motion, although it's not said expressly, it's implicit, but I want to make it express because I want to be very clear about it. They are saying that we, the 5 of us and Ms. Fugate, the 6 of us, breached your order, violated our duties to this court, violated our professional obligations, and gave those materials to our client, Mr. Delario, Mr. Denton, and that they then gave them to the National Enquirer. And, you know, we have repeatedly emphasized that that's not true. And I think what they're hoping, Your Honor, look, let me be blunt if I could, Your Honor. I think it's important to be honest at this moment because this is a difficult moment, right? We have had a professional, but in many respects difficult relationship over the past 3 years. You have a very different conception of this case than I do. We have, right, you're smiling knowingly, that's correct, right? We have a different version. We have come in, and let's be honest with each other, Your Honor, we've appealed you a lot and you've been reversed a lot. And I don't say that to be flip. I say that to just be honest about what's going on. And I think the plaintiff is hoping that you're annoyed. I mean, I'm probably really annoying, and I'm sure when I leave here and, you know, or you get handed an order by the DCA that's a reversal, you go back in your chambers and you go, ugh, Berlin, right? And it's annoying.
I say not right, so I won't agree to that.
All right, but
I have a number of interns that are in here. I find the attorneys in this case to have been highly professional. It's an interesting case. It poses very interesting, very serious constitutional law issues, which I find to be challenging, and it's certainly more interesting than a number of the mortgage foreclosures that we have a lot of. So, no, Mr. Berlin, when the appellate courts send me instructions, I take them to heart. I don't necessarily accuse the lawyers. I think it's just part of the system that we live in, and I'm grateful that we do have this system. I think it's a wonderful system. It's the best in the world.
Delighted to hear that, Your Honor. My point was simply this, which is, even though we have disagreed, and in some cases strongly, about the merits of the case, I don't ever think for a moment that what the plaintiff, I think, is hoping is that, in frustration about that you might stick it to us, the lawyers who have made that happen, and I know that not in my heart of hearts that that's not true. I agree with what you just said. And we know, right, we know that you know, because you have eyeballed all of us for 3 years now. I know in my heart of hearts that although you think I disagree with you, that I think you, and you just articulated this, that we have behaved honorably in this case and throughout this case, and that if we had a disagreement, we didn't just ignore a court order and violate it. We took an appeal or a writ, right? And that's how we behaved. And what they're essentially asking you to do is to go down a road that before it gets to Mr. Delario and Mr. Denton and picking out, you know, I'm going to credit this sentence and not that sentence of his article, that it had to go through us. And what they are essentially saying, Your Honor, and what you are essentially being asked to find, is that these lawyers, standing in front of you and who have stood in front of you again and again over the last 3 years, violated your order, violated their obligations as officers of the court, and that's what we're going down this road. And I think, I give you credit, I think in your heart of hearts you know that that's not true. And that's why I ask you not to enter this order. And I'll sit down.
I understand the gravity of the situation. I understand the seriousness that you all take it, and I appreciate that. Mr. Trickett?
May it please the court. I was hopeful, Judge, when this started because Mr. Berlin said he was going to address 3 things. And so I did what I was taught in law school. I started writing them down, and I put 1. So I would have a list, and then I could just rebut them in order, and we wouldn't go through everything we had gone through before because you read everything, and we have a binder full of materials. And then he addressed 1 thing, and I completely lost him after that, and I don't really even know what the other 2 were other than some discussion about the order. There are a few things I want to show you that are either in the record or been referenced in the record, but I want to make sure they're in front of you today. I don't know how to answer that last part, and it'd be remiss in my obligations to Mr. Bolea not to say something about it. Judge, we...
Say anything about it.
Okay, well then I'll leave most of that out, other than the fact that they've grossly misread our paper. And Judge, I'm going to start this where I started this the last time. This is a case in which we're trying, and have been trying, to enforce our clients' rights of privacy because a videotape was taken of him surreptitiously without his consent and published on the internet by Gawker of him engaged in perhaps the most private act in the most private place you can have on this planet. They've said that the First Amendment allows them to do it. That's what the pleadings frame in this case, and that's what we've been trying to do here. To the extent there's a sideshow, to the extent that there has been ancillary issues created, I can assure you it hasn't been by us. We're not the ones who stood on the federal courthouse steps and accused the Bolea team of conspiring with the FBI. Of course, not in a forum where they can be accountable for those words, but to the media. We're not accusing the attorneys of anything, Judge, and I'll leave it at that. We don't know what happened, and I think that's the premise. And I don't think when Mr. Berlin, and to the extent Mr. Berlin and Mr. Thomas and Mr. Berry and Mr. Sullivan read our papers to say the lawyers were actively engaged in doing this, I'm not sure whether that's just paranoia or me thinks they protest too much, but that's not the gist of it, Judge. E-discovery happens every day in the courts of the state of Florida. I know the court knows that. We live in a world now where we just don't get the whole story anymore from paper. We've put before you a timeline. The timeline is based on evidence. They say it's speculation, but what it would be commonly referred to in a court of law, whether it be before a judge or a jury, is circumstantial evidence, which I know the court is aware is sufficient to convict somebody of murder in the state of Florida. Unfortunately, when people do bad things, they don't often leave a direct trail. They don't often leave the evidence out there, so you have to piece it together. And so we pieced it together and we gave you the timeline. And the timeline isn't speculative. It's based on things that were said and printed, etc. I find it interesting for a company that preaches transparency and free reign over everybody's facts in life that they've chosen this issue to assert, I guess, their own privacy rights or something. But what I found the argument going to, Judge, listen, if Your Honor thinks the order is too expansive, if there are areas of it where they need more time, Judge, we'll defer to the court's judgment on that, with the only caveat being we are set for trial in March, and I do expect them to object to anything that eHound says. In other words, if eHounds put something out there and they have a 7-day meet and confer, I expect on the 7th day of the meet and confer to get the meet and confer.
Let me ask you, did the plaintiff utilize eHounds in the past in this litigation?
I think we used them for the sweep of Mr. Bolea's text messages, right?
Yes.
Mr. Hogan, no, because he's talked to them,
And
actually.
Your Honor, before we put him in the order, I did speak to him and asked him initially, is there anyone else you would recommend locally? And the only individual he would recommend is retired. So that's why we included him, but we were aware of that issue.
So I don't think it would be appropriate for eHounds to serve in this capacity as of previously serving with the plaintiff. So if there's somebody else that could be utilized, if you all can agree on, that would be the best. If you can't agree on them, then I'll get somebody.
There's a handful, Judge. My guess is the ones we would suggest would be the same ones you would end up picking because there's not that many in the Bay Area, but we'll find somebody. That's not particularly hard to do. And if we have to get someone from Orlando or from... Okay, I'm sure.
If I can just answer the question, because Your Honor, I'm sorry to interrupt. I asked Mr. Thomas when I sat down, and he said that the ones that he's aware of that we have the same problem, which is that somebody that we used in this case. So we would have to look for somebody else.
We'll find somebody. Judge, and so if that is the issue, and I thought that's kind of where Mr. Berlin was going to focus, but he didn't really. But the point is, Judge, if you're going to change the deadlines, we're fine with it, Judge, as long as we keep in mind the fact that any time there's been a period in which objections have been allowed routinely, you have to look at the back end of that period because that's how it always ends up. So if there's a 7-day meet and confer, the meet and confer is day 7. If there's a 10-day objection period, we'll get the objection on day 10, and if we can set it for hearing in 30, it's going to be set on the 30th day, and we are trying it in March. So the fact, though, Judge, that I'm sorry, my phone's buzzing and I want to turn it off. The fact that they say that we've distinguished all their cases. I mean, they cited a bunch of cases that prohibited this practice when a case was closed, people coming back in contempt settings after the fact. This is Florida Rules of Civil Procedure e-discovery. We deal with it every day. The difference here is the topic is the violation of a court order that I think Mr. Berlin referred to as being unusual because it doesn't relate to the allegations in the complaint, but violation of a court order. That were the words he used, was the words he used. Judge, I'm going to try and make my points without being too redundant, but this was evidence that they sought to use in multiple depositions and were told no by Judge Case. This was evidence that we had a full-blown motion in limine on and were told that isn't coming into this trial because it's not the tape at issue. We've put that in our timeline. I'm going to go through a couple documents and I'm going to sit down, Judge, because I think we've briefed in our reply. We've responded to everything. They gave you a laundry list, Judge. Keith Davidson signed a statement under oath that he doesn't have this. Nick Ritchie said he doesn't have it. You can go down that list. It's almost as if their argument is when the inquirer tells the court, not under oath and not in front of this forum, that Gawker didn't do what you're supposed to believe it, but any other evidence that may indicate they did, you can't believe. That's a fact fight, Judge. And ultimately, if this e-discovery doesn't bear it out, we're not going to bring the motion. If it does, we're going to bring a very serious motion because I think it falls right into the category of Cozell and contumacious disregard of a court order. Judge, if I may approach, I just want to go through a few documents here and then I'll be done. And I'm handing a copy of this to defense counsel. Judge, lest we be accused of unsupported, unsubstantiated paranoia, it's not as if Gawker has not disregarded a court order in the past in this case. And I know you know that, but I do in some respects want to make a record of it in the sense that Your Honor has issued an order in the past which Gawker not only disregarded, but published an article saying they were going to disregard. Judge, as to the substance of the Inquirer article, I think on page 8 of Gawker's, if I may approach, on page 8 of Gawker's reply or opposition brief, joint opposition, they make the point that, and I actually I copied it verbatim because I was somewhat amazed at the bullet point. And I want to, as Inquirer never claimed to have access to documents produced in this litigation. And I think Mr. Berlin made quite a bit of argument about that it's not the same document, it's not the same transcript. The Inquirer article, Judge, and we've sort of red circled it. First, they say, after acquiring the bombshell transcript of Hulk Hogan's N-word racist rants. And then they circle the Denton post from July 10th. The deeper you go, the more interesting it gets. And so we continue to follow that sort of line factually as we put the circumstantial facts ahead of the court, in front of the court, and found, if I may approach, Judge, yet another. And this is Exhibit C to our opposition. Thank you. Exhibit C to our reply paper. Okay. And this, Judge, I think is critical. And we've highlighted it. It says, according to the transcript, filed under seal in a Florida court. Now, how would the National Enquirer get a transcript, A, that was filed under seal, and more importantly, Your Honor, know it was filed under seal? At the end there, Mr. Berlin was saying, we did this. I can promise you, I'll swear to you right now, we didn't talk to the Inquirer and tell him, hey, here's a sealed transcript of my client saying horrible things that we don't want out in the public domain. Go ahead and publish it so we look better in front of Judge Campbell. It's absurd. I mean, it's an incredible argument. So that's what the Inquirer wrote, Judge. What do we know at this point as attorneys other than what they've put out there? So they, according to their own words, have a sealed transcript that was filed in this court that would have been protected by this court's order. They make quite a position in their paper about it's not the same one. It's not the same one that Davidson had that they tried to use in the depositions. Judge, we don't know. And I think that's the point of conducting the discovery. But we do know they had a sealed transcript. Judge, following this lineup, and again, this is another exhibit in our reply, and if I may approach again, and I'm handing a copy to defense counsel, Exhibit A to our reply, and this really factually sort of takes us down the path of where we think this ultimately goes. A.J. Deloria is a defendant in this case, Your Honor. He's a former Gawker employee. He is the one who edited and published the Hulk Hogan sex tape article. He was set up in this company, Ratter, financed by Nick Denton to the tune of $500,000, Nick Denton being the principal of Gawker. Ratter is essentially, as best as we can tell, the new Gawker. But Deloria is friends with the Inquirer editor, I forget the guy's name, and we briefed this. It's 6:52 a.m. the day that the Hulk Hogan leak was published by the Inquirer and by Radar Online, its affiliate. Deloria tweets with a hashtag at Hulk Hogan. It says hashtag FF at Hulk Hogan XOXOXO, which is text vernacular for hugs and kisses, I think, and links the story. Judge, the story, if you look at it, was published, if I may approach again, a mere 14 minutes before Deloria was prepared to text to my client the news of its leak with this snippy, morbid XOXO, like this is some kind of joke. And so, Judge, that's the circumstantial evidence in addition to what we've already briefed. We're entitled to conduct discovery. That's all we're asking for, Your Honor. It's not a fight right now of who did what or whether you're going to rule on it. It's a fight of letting us look behind Deloria's text, behind Deloria's electronic evidence, behind Denton and Deloria's electronic evidence, to see who was talking to who. And Judge, I don't think it's particularly far-fetched that Denton, in light of the huge implosion at Gawker at the time, and Deloria got together to try and distract attention from what was going on in their house by doing this. That's a very plausible theory. There are others, but that to me seems like a very plausible one right now. So, Judge, we're open to a reasonable, rational discussion on a material narrowing that makes sense in the court's eyes, with the idea that we are set for trial in March, and there are certain things. Judge, privileges, we're not going to fight. If there's a spousal privilege issue, they can list it with attorney-client work product, and we'll vet it. I mean, but past that, Your Honor, if you don't have any questions, we think we're entitled to this order and would like some iteration of it entered. Thank you.
Can we put at least a time frame so that the parties can talk about who would be the electronic computer forensic person, and then if you can submit to me one that you all agree to, that would be great. If you can't, then maybe both of you propose a couple of names, and I appreciate it. Whatever the couple of names are, I'm going to believe that your representation to me is that neither side, that you haven't used them, those that you're proposing, and the plaintiff hasn't used the ones that you're proposing. Go ahead.
It seems from your comments, Your Honor, that maybe you've already indicated that you're going to go down this road, and that's, I would just say briefly, and I'll try and be brief, but make my record, that I think that's unfortunate because Mr. Tuchel admitted in his first comments that he was not accusing the attorneys of anything, and as I pointed out, before you get to Mr. Denton or Mr. Deloria, you gave these documents to us, and it requires us to have violated a court order, and I think that is the beginning and the end of the matter. What we have here is, Mr. Tuchel talked about circumstantial evidence. It is true that you can find things from circumstantial evidence. I'm not going to argue that point. I would lose that point. But circumstantial evidence doesn't mean let's pick this piece of evidence while ignoring that, this sentence, and we'll ignore that sentence, this thing and ignore that, and that's what we have here. And we have not just an order that is saying, let me see what happened to Mr. Deloria and Mr. Denton, but it talks about all of the employees of Gawker. It talks about, Ms. Dietrich, who's their in-house lawyer, and literally includes, all of our work product, including on this case. You're basically saying, let's have the court look at or cross-examination outlined for the plaintiff or for other witnesses, and which is going to clearly come up from a search that includes the words Hogan or Balea. And that really is just, that process of rummaging through is just not permitted, and especially, they talked about e-discovery is common. It's not common for the court to do it. It's common for parties to do it, and we've done a bunch of it in this case, as the court knows. So,
That's why I like the appointment of a special magistrate.
well, I don't know if you want me to address that piece now. I'm happy to.
Address it whenever you like, but I think that is a critical component of it. I've often found in cases, sometimes it's not really appropriate for me to hear everything. And in fact, in going back through some of the transcripts that everybody provided for some of the other parts of this hearing, it's clear. I don't know all the facts. I rely on the attorneys to know all the facts, or as much as you can, or as much as you get to discover, but I don't know all the facts. And having a special magistrate creates somewhat of a buffer so that some of the facts is not important for me to know. So,
Well, Your Honor, look, we can argue the merits of whether it's a good thing or a bad thing, but my understanding, and it's pretty clear in the law, is that it requires the party's consent, and that a party may withdraw its consent. One of the cases we cited involved the involvement of a magistrate to try and help out work it through the filing of a complaint, of an amended complaint, which the parties consented to, and then there was a later amended complaint, almost the exact same issue, and one of the parties said, no, we no longer consent to having a special magistrate, and the court went ahead anyway, and that was the subject of a writ, and the DCA had no problem saying, no, the rule requires consent. So I want to just be, I realize that's your position. I don't know that there's a lot of margin to be spent arguing it, but to simply say it's quite clear under all of the cases we've cited that ongoing and continued consent is required, and certainly in this instance, you have a situation where not only are you talking about Denton, Delario, and Gawker, but you're talking about other employees who are not before this court, who have not consented to Judge Case, and now he's appointed to hear their stuff. And I just think that that's improper, and want to memorialize that objection. If the court's already made up its mind, then so be it. And let me, if you'll just indulge me a moment, I just want to consult with my co-counsel for 1 second. Let me just reiterate what I just said, Your Honor, so that it's clear. I just want to be clear that, there are a lot of people who are not parties to this case that are swept up in this order, and none of those parties, or none of those folks have consented to being before this court, let alone being, consenting to proceed on this issue before a special discovery magistrate, and I feel like I need to memorialize that as well. But unless the court has any questions, I will sit down. Thank you, Your Honor.
Just one point with respect to that last point, which didn't come up in his first argument. Yes, Gawker is its employees. They are Gawker, so I don't believe they have any separate rights from any employee of Gawker. And I don't think I said in my first part, but Ms. Dietrich, in addition to being general counsel, is an officer of the company, and we've already briefed that before the court. Lastly, we briefed the Judge Case issue. They consented to an order. The order was entered. That's what happens. We've already made it clear you can't withdraw consent after the order's entered. So.
all right, so now I think so what I'll do is pull all this together. You all consider the name. You think that you could do it in another week or so?
Yes.
7 days, 10 days, a couple weeks anyway, and
How
then
about
that way.
7?
Fine. Rather than talking about
Oh, Rogers from Holland United.
Okay, so we don't have Mr. Connor anymore?
Mr. Connor couldn't be here for this year.
Are you out of the Jacksonville office?
No, I'm out of the Orlando office.
Thank you. So, Ms. Steele, you're going to allow him to argue it, or you're arguing it with him?
I'm going to allow him to speak, Your Honor.
Okay,
Thank
good.
you.
All right.
Your Honor, if I may, I mean, we definitely would like the press to be heard on this. We filed motions as well that I think that they essentially joined in, but Mr. Rogers can speak to that, so we would definitely like to be
I
heard.
think he's going to give you like an opening statement overview, probably all this, what I imagine you're going to do, right?
Well, yes.
Otherwise, I'm going to just start plowing through one by one. And so I don't know if you want to give me an overview, or you want to be heard on each and every one, or you're just going to raise your hand at that particular time.
Yeah, no, I'll focus on an overview. Really, our focus, Your Honor, is on the documents for which there was already the FOIA order issued by Judge Bucklew in the Middle District Court. Your Honors, as you're already aware, Judge Bucklew already entered an order determining that those documents that were disclosed by the FBI are public records. The media, my clients specifically, First Look and such, consider it very important to be able to be need access to those records, not only because they have already been determined to be public records by the district court, but also because it's an issue that's integral in this case. What we have had repeatedly here, from what we can tell by looking at the public records, are numerous motions before the court indicating the sealing of many documents, basically by attorneys having labeled them already for attorneys' eyes only. Of course, the counsel from both sides have been have complied with those orders, but those all those documents have been deprived of the press's attention. And of course, it's critical for the press here to be able to understand the issues that are going on in these cases. There has not yet these documents that had already been produced or have already been determined by the district court to be public records.
Can I ask you a question about that? Because if Judge Bucklew, I'm not aware of the order that said from Judge Bucklew, and I don't really follow all Judge Bucklew's rulings. All I get is what the attorney sent to me. So if Judge Bucklew's already entered an order that says it's public record, why are we even here?
Well, because, Your Honor, we still don't have access to the records. The records are still being labeled attorneys' eyes only. They're in the hands of Gawker's attorneys pursuant to the orders that have previously been issued with this court.
So you weren't able to get them from the federal court case?
No, because basically from my understanding is Mr. Belia is taking the position that notwithstanding that order before, those documents were ordered to be produced only to Gawker, not to be made public, and that's.
She ordered them just produced to one of the other parties, not that they were open and she didn't just open them up to the public.
Well, her order specified that they are public records, and for the purposes of that litigation, she did indicate that those are public records. Unfortunately, the position that's being taken by the plaintiff now is that because they're still marked attorney's eyes only, the public doesn't have access to those records. And of course, the key role of the media here is to be able to understand. We have a leaks investigation that's an integral issue in this case. The FBI leaks investigation issues to which those documents related, and it's in the interest of the public to be able to understand those issues. So the problem that we have, Your Honor, of course we intervened before when Mr. Connor was here before, talking mainly, as I understand, about the video issue, is that the press has been denied access. And unfortunately, the effect of what's going on here is that even though we already have the federal district court's order, the public access is still being denied under the guise of your previous order.
I have a copy of that order. May I read, Your Honor? I don't have extra copies. They probably have their own.
If you just maybe show them what you're handing me so that they see it.
This is Judge Buckley's July 1st, 2015 order.
Thank you.
Thank you, Your Honor.
Your Honor, I think what's particularly critical here is that because of the nature of the way the order's been issued right now, under Rule 2.420, if a document is going to be filed under seal, the court needs to make determinations of the rule, the application of the rule, the reasons to keep those sealed, document by document, redaction by redaction. And unfortunately, the effect of the proceedings right now is to have a blanket order where the public's denied access to numerous documents for which no specific findings have been made. I'm sorry?
That's what we're here for today.
Exactly. Well, I understand, and that's why we're respectfully asking for you to grant the public access to that. And I'm happy to answer any other questions that you might have, or to wait, allow him to respond.
All right, thank you, but I think what this order says, as well as all the other orders from the different various courts, each court looks to the rules that they are under and the issues that are before them. So I think we all look at it in a different format based on what's before us, so. Okay.
And I understand, Your Honor. I think that the key problem that we have is that we have not yet, to my understanding, based upon the orders that we've had before, had specific findings by the court made document by document, redaction by redaction. And that's why we're asking for these documents to be made public.
All right, does either party, Mr. Barry, want to make like an opening overview? Otherwise, we're going to just start plowing through them.
Absolutely, Your Honor, thank you.
You want to make an opening?
I would,
Okay.
I would.
I appreciate what Mr. Rogers said. Beyond the FOIA records, there's an extraordinary number of records that have been filed by the parties provisionally under seal in this court. There have been a number of proceedings that have been conducted behind closed doors that have not been open to the public. None of those records and none of those proceedings have been properly sealed at this point. There are no rulings at this point on over 17 motions to determine confidentiality of records, and that's why we're here today. There's no findings on the record justifying the order closing these binders of documents, these binders of records. There's no justification for the closure. These evidence and arguments are integral to the proceedings and the rulings, and I'd like to talk about that in a bit. Much of the information that's been sealed is no longer confidential. There's been multiple rulings in this court, and I'll talk about them in a moment, that's been based on secret argument and based on secret evidence. And the public should know the truth. It's not just the FOIA records. They should see the evidence for each of the rulings along the way. They should review each counsel's arguments, and they should be able to be exposed in the light of day. Under the First Amendment in Florida law, there's a strong presumption of public access. Records are subject to sunshine, as are proceedings. The Florida Supreme Court made this clear in the Barron case, saying in this country, it is a first principle that people have a right to know what is done in their courts. As the court said just a couple years back in the amending Florida Rule 2.420, Florida law strongly disfavors court records that are hidden from public scrutiny. As the Florida Supreme Court and the United States Supreme Court have explained, open access to records and to proceedings is fundamental to the operation of the courts and to a free and democratic society. And there's reasons that the courts have said that. It ensures fair administration of justice for the parties. It allows the public to review evidence and arguments on which courts base their decisions, therefore resulting in instilling public confidence in the court system and the justice is being done. It allows the public to scrutinize what the parties and lawyers tell the court. And in that regard, the Barron Court, the Supreme Court of Florida, said that access to court proceedings, quote, improves the quality of testimony and produces a, quote, disinclination to falsify. The Florida Supreme Court has been very clear that the party seeking closure bears a burden, and that burden is a heavy burden. Closure is only permitted by the Supreme Court and under Rule 2.420 in limited circumstances and only a narrow category of documents. Those interests are protected under 2.420, and there's only a handful of interests that are protected. The rule explains that the closure must be narrowly tailored. The degree, the duration, the manner of confidentiality must be no broader than necessary to protect that limited number of interests set forth in the law. As the rule says, there must be no less restrictive means to protect those interests. There simply must be no reasonable alternative to sealing. As Mr. Rogers said when he was up here, in Barron, the Supreme Court said that you cannot close court proceedings or records when a record is inherent in the type of proceeding sought to be closed. And Barron gives a great example of that. The issue in that case dealt with a divorce proceeding, and there was closure, party asked for closure because they were submitting medical information. Medical information didn't bear on the divorce itself, but bared on whatever the party came to court to ask. And the court said, even though that medical information doesn't deal with the divorce, it does deal with what you're asking for relief on. Therefore, it should be open. And the courts in this state have emphasized that a litigant does not have a reasonable expectation of privacy in the subject matter of his lawsuit. These same principles apply with equal force when discovery material is filed with the court and on which a court bases its decision. Florida Supreme Court made that clear in the Palm Beach newspaper's case, citing our paper. Once a transcribed deposition is filed with the court, it's open to public inspection. Now, the plaintiff, in opposing our motion, has said that somehow we have the burden here. That's simply not true. It both misstates the law and it misstates the facts of what's happened so far in this proceeding. Each case that the plaintiff has cited in their brief dealt with an issue where there had been proper hearings and proper closures, and then the presumption was switched once those proceedings, findings, and rulings had been made. That's not the case here. The key case that all of their cases rely on is a 1986 decision called Sentinel Communications out of the 5th DCA. That case was decided in 1986. 2 years later, the Florida Supreme Court decided Barron and specifically rejected Sentinel's analysis and said, we also I'm sorry. All right.
Party seeking closure continues to have the burden to justify the closure.
Correct.
So I'm with you on that one.
Correct. And so then Rule 2.420 was amended after all of those cases were decided to set forth the procedure for sealing. You must hold a hearing on the motion for sealing. That hearing must be done as soon as practicable. There must be an order ruling on the motion. There must be grounds for confidentiality set forth exactly in that order. Set forth who can see the stuff that is filed. And a finding that the closure is as narrowly tailored as possible and that there's no less restrictive means. Here, we've never gone through that procedure. The plaintiff has never made any showing. The court did not make any finding. There hasn't been any rulings. And you've never ordered documents to be sealed. So when they come before the court and say there's proper sealing orders, that is simply not correct. Here, the public has a tremendously strong interest in access to records and proceedings. Your Honor talked about this earlier with Mr. Berlin. This raises interesting constitutional issues. You have a high-profile case with members from the media sitting out here with us today, sitting on the front stoops of the court. It involves an international celebrity. It involves one of the most highly read websites in America today. It involves significant issues about the right to privacy. What does a person have a right to control of themselves? Significant interests about the First Amendment and the free press and what it's free to publish about celebrities in this day and age. You now have accusations of a leak and accusations that a responsible website, the council may have leaked material that's made national and international news. On the flip side, you have us saying that there's been false accusations, that there's been false statements made to Your Honor, that there's been false testimony. All of this are serious charges. No matter who you believe, the public should have an opportunity to scrutinize that and to compare what's being told to you and what your rulings are being based on. There were no grounds for closure initially. Over the past 18, 19, 20 months, this stuff has been filed under seal. He's come forward, the plaintiff has, in his papers, and has said essentially that he has a preference to keep these matters hidden. It might be embarrassing to him if some stuff is disclosed, but that preference is not a sufficient ground under Florida law. Most of what his argument centers on is the contents of videotapes, whether visual or audio, what was being depicted and what was being said. We do not have the recording that he's concerned about being exposed. It's not in the court files, so that is not an issue. The vast majority of the documents that are sealed have nothing in them relating to graphic sex. They do not include the words that they accuse us of leaking. There's only a couple of documents that deal with the specific terms that have been said to have been leaked, and those documents, as we've said before, don't match. But their biggest concerns are not included anywhere in these materials. The plaintiff has suggested in his opposition that somehow the release of these materials, whether it's the FOIA stuff or everything else in these documents, could somehow compromise a law enforcement proceeding. Well, there's a few things that they've left out. First, Your Honor rejected that argument when you ordered them to produce their law enforcement records. Your Honor rejected that argument again when you ordered the plaintiff to sign a FOIA waiver. The DCA rejected that argument when it declined their writ petition on the FOIA waiver. And most significantly, the federal government in the FOIA action has never argued that this would interfere with a law enforcement proceeding. Indeed, in dealing with the prior issues before Your Honor, the U.S. Attorney's Office said there's no problem if this stuff is provided and you talk to the people involved. They've already declined a prosecution, and that happened years ago. The records that are sealed provide the basis for significant court rulings throughout this case. They're inherent to these proceedings, as Mr. Rogers said. And I'll just tick off a few. First, the Special Discovery Magistrate, and then Your Honor, said that no sanction should be levied against the plaintiff for various misstatements and discovery abuses that we allege. The public should know the basis for that ruling and what we were saying and be able to test that against reality. Second, the plaintiff was allowed to redact any reference to the use of racial language during this case, including evidence that was produced to us directly by third parties and was ordered by the Special Discovery Magistrate to redact and expunge from deposition transcripts so that they wouldn't see the light of day. The public should be permitted to know why that was allowed. We're now being accused of redacting that material. The public should be allowed to see that we were prevented from getting it. Whether the plaintiff said the same things to Your Honor, whether his counsel said the same things to the Special Discovery Magistrate that he so freely said to People Magazine and Good Morning America, the public should be able to know in looking at whether those redactions were allowed appropriately. Your Honor denied summary judgment several months back, sent the case to trial after a federal judge and the DCA had already said that this was protected speech under the First Amendment. Obviously, we disagree on the law, but the public should know what evidence you were looking at in making that contrary ruling. As of now, much of it is under seal. You ordered this case to be severed and to go to trial several months back in October actually of last year. That decision was reversed. Our filings concerning the severance are under seal. The public should know what evidence was presented to you at that time in making your decision on that issue. You denied our request for continuance in the run-up to trial. The exhibits to that motion are filed under seal, and it includes correspondence from plaintiff's counsel to the federal government, some of which was not produced to us in discovery and should have been, but that casts into questions a number of things that preceding this that are also under seal. The public should know what evidence Your Honor was looking at when you made those rulings. This is not a system of secret justice. This is the United States of America, as you said. It's a wonderful system. This is the system that we live in. It's not the Soviet Union in the 60s and 70s. It's the Sunshine State of Florida, and the public should see sunshine in this courtroom. They should have access to every transcript that has been put under seal and every document that has been closed. The basis for confidentiality for the broad stroke types of things that they're concerned about no longer applies. The information simply isn't confidential. It's known that Keith Davidson allegedly extorted the plaintiff. He put that in papers. He filed publicly in California. It's known that the plaintiff and his counsel, David Houston, participated in a sting operation. They've talked about that in their filings. It's known that there were 3 tapes of the plaintiff and Heather Clem. They know that there is no prosecution. The government put that in its filings in federal court. Plaintiff's counsel has discussed it in this open court. It's known that the plaintiffs used racist language on one of the DVDs, and it's known that that was not the DVD that we had. The plaintiff publicly disclosed that, not us. The last thing that they've accused us of is that we filed this motion as a pretext, that the only reason that we're doing it is because now we're being accused of a leak. These motions have been pending for 18 months in many cases. They do bear on this leak issue, but this was an issue that first came up 18 months ago where we had a hearing in Judge Case in a room that wasn't even in the courthouse. The accusations being leveled against Gawker and the law firms here have been reported in headlines around the world. That's why we have the press sitting here today. As I said before, there's serious accusations and there's tremendous public interest in knowing the truth. The public should see whether those accusations are justified, whether it's meritorious to suggest that my clients had anything to do with this leak. The public should see the arguments that they've made, which they've been able to make in open court. They have not been able to see the evidence that we've presented because the plaintiff has designated that to be sealed. There have been a number of misrepresentations and statements made. The public should be able to decide for themselves whether those misrepresentations or those statements that have been made in this very courtroom, standing at this very lectern, in closed depositions that have been taken under oath, whether our charges of falsity are correct. The public should be able to see why the plaintiff was allowed to make the designations that he made, why he's allowed to designate stuff as confidential, and the decisions that Your Honor and Judge Case made that allowed that to continue to be done. And the public has an opportunity to decide for itself whether this whole offensive language issue and evidence of this investigation has any bearing on these proceedings. Your Honor ruled in the motions in limine hearing on July 1st that neither the evidence relating to offensive language or the FBI investigation was going to be admissible. But that ruling, despite what plaintiff says in his papers, was expressly without prejudice. I stood in that very chair and I asked, Your Honor, is this going to be without prejudice? And you said yes. Quote, if you learn something else from the FBI, and that's why I was saying this is based on what we know now. That afternoon, maybe the following day, the FBI produced those documents to us. The world is very different. Those documents, despite what plaintiff says in his papers, are relevant and admissible for many reasons. In the run-up to trial, we'll give you specifics. But first, as they say in their papers, we did say at the very beginning of this case, when we sought down this road of looking for law enforcement records, that we're entitled to find out the statements that plaintiff and his counsel made to the FBI. We didn't know what they were. We said maybe they will show about his knowledge of cameras and the filmings. Can't get into the details, but the FBI records bear on that issue. It deals with the credibility of plaintiff and other key witnesses. They've testified one way in this court, in their depositions in this case, said very different things to the FBI. Both of those things, though, right now are all under seal, and the evidence from the FBI undercuts that testimony, even beyond what people are saying that's different in testimony in this case and what they told the FBI. The evidence shows something else. And most importantly, Your Honor, this whole business about the race cuts right to the heart of plaintiff's damages. For 3 years, he has stood on the courthouse steps when he filed this lawsuit, and he's come in this court time and again, and he has said, I am distressed because this company published some excerpts and grainy video of a sex tape. That's what this is all about, $100 million. That's what this is all about. The fact of the matter is that that is not what his distress was about. What he was actually concerned about and what his real damages are revealed in those FBI records. It's a theory that we have articulated at various points, but we weren't able to connect the dots. Your Honor, this stuff is relevant and it's admissible. It has nothing to do at this point with whether the other records have been sealed, but it's an argument that they're continuing to make that Mr. Turkel made earlier. Your Honor denied that motion without prejudice, and there's good reason that it will come up again. I'm happy to go through the records record by record. It's their burden, so perhaps it'd be better for them to do that, though.
it sounds good to hear all the sound bites and the snippets for the news about how important our open records laws and the sunshine and things of that nature, but they're making those statements to you without actually going into specifics on the context. They're not actually applying those laws to the facts of what this case is about. This case is about one video that was posted on a website and whether it was newsworthy, period. That's it. This case isn't about race. It's not about an extortion investigation, and it's not about other tapes. It's not. The context that they're bringing this up in, it's really important. It's a gossip website, and fellow members of the media are asking you to make illegally and secretly recorded footage of Mr. Boulay naked and having sex, and files relating to his efforts to stop someone from extorting him with that and threatening to make them public, that are not at issue in this case, that Mr. Berlin himself, when he started talking to you today, said were tangential to this case. They want you to use that as an excuse to let the public see the very things that Mr. Boulay fought so hard to keep private. That's scary. That's scary to stop and think that when someone goes to law enforcement to stop someone from disclosing private parts of their lives that were illegally obtained, that opens the door for the press to go in and get access to the very thing that they sought to protect. And they're making that argument, ironically, on the day when the revenge porn law came into effect in this state. And it makes me wonder, they refer to Mr. Boulay as an international celebrity, and it makes me wonder if we would even be having these arguments today if we were talking about a woman. Would we be arguing over this if we were talking about a woman instead of a 62-year-old professional wrestler? Would someone have the audacity to come in here to you and argue that secretly recorded illegal video of a woman naked and having sex, and then her effort to stop someone from making that public, whether they would have the audacity to come here and say everything about that should be public, Your Honor, because that's what this motion is. They want a wholesale public disclosure of everything that was the fruit of that illegal activity and that secret recording, none of which has anything to do with why we're actually here. This theory to inject race into this case keeps morphing over time. The last time that they made this argument to you and you excluded the evidence from trial, it made any sense to me, because the last thing you would do if you knew that the FBI had these things and they were protected is go file a lawsuit and potentially open them up to the public. Well, that failed. So now we get this new argument that, it's really about what his distress was really over. They can't do this. They can't just change the story every time they want to try to inject these completely irrelevant issues into this case. And that's what they're trying to do. And because you won't let them do that on something that has no bearing on what we're here to actually litigate, this is the route that they're now taking. They want to make it public. They want the media to come in and join them and pile on top of Mr. Boulay. And they want to do that because you won't let it in this courtroom, so they want to try this case in the press. And this is a total manipulation and perversion of the public record laws and what they are intended for. We're not here arguing about releasing these in the public interest. That's not why they're here. The public has no interest whatsoever, none, in seeing illegally recorded footage and investigative files about that footage of someone naked and having sex. And I know they have no interest in that because we just passed a law making that illegal. I know they have no interest in that because we already have a law making it illegal to disclose recordings of people without their knowledge or their consent. The mere disclosure of it. That's the public interest that we're talking about today. We're not talking about the sunshine. They make this contention, this argument that they're unable to defend themselves and they're having a secret and private trial. Let's go back to the context. They've got a team of expert lawyers in the First Amendment. Very, very good lawyers. They've drafted exhaustive summary judgment motions. Exhaustive. We were on the doorsteps getting ready to go to trial, and everybody was ready and fully prepared. So their contention that they can't defend themselves in the case without getting access to these documents does not hold water whatsoever. You know, I think it's extremely important, Your Honor, that that context comes front and center in this case. These records that we're talking about, the only reason they got access to those records, and I want to clarify this with respect to Mr. Rogers' argument. Over Mr. Belea's objection, they were able to convince you to order him to sign a limited FOIA waiver so they could get access to the FBI's files, because the FBI would not produce them because they're private. He has a privacy interest in everything in that file. So they had to come to get an order to you. And when they came and got that order from you, what they said was, Judge, we need this because we think this stuff is going to show that he knew he was being recorded and he was in on it. That's what they told you. And you said, you know what, that makes sense. I'll buy that. I'll let you have limited access to him. But this FOIA waiver is attorney's eyes only. We're going to figure out whether they say that or not, whether they're relevant. And if they're not, they're never going to see this courtroom because he has a privacy right in those things. That's how we got here. And the district court recognized that. That protocol was followed. She didn't order that these are public records. Matter of fact, we filed a motion for protective order in there, and she entered a subsequent order deferring to you, saying, if you want that clarification, go to Judge Campbell to do it. And we did that. And you entered your order you entered last week, clarifying that that privacy waiver was limited, and it was limited for good reason. And now, not once, in the papers, in Mr. Berry's argument, have you heard once that those records show that he knew that he was being recorded and that he was in on it? Because they don't. They don't. Now, you see the real reason they wanted them. And this ties into the other motions that we filed today. The real reason they wanted them is so they can publish stories about it. Mr. Boleyn said that in federal court. Now our reason's different. Yes, originally we wanted them for discovery and to see if there was consent.
Your Honor, I'm sorry, I have to object. I cannot stand here and have Mr. Vogt misrepresent to that degree what's going on. It's just improper. I will sit down.
I can get the transcript.
I have it. I'll be happy to hand it up to the court.
So, you know, Your Honor, I don't think that can be overlooked whatsoever in this situation. We're going off on tangential issues now.
I do think that it was important to have, in fact, in going through all the different notebooks, it was a little confusing in the beginning to get the rhythm, because some of the motions were filed in 2014. I'm thinking, I think I've already seen this, but maybe I hadn't seen them, so it took me a while to sort of get with the flow of it all. But I think it is important to make sure that the clerk has clear understanding as to which things should remain confidential and sealed, which things shouldn't remain confidential and sealed. I think it's important for our proceeding, for the trial, for there to be clarity. So I agree with the concept of we should go through and make sure that there is clarity and that there is sufficient rulings and a basis under 2.420 for them to be sealed, if they're to be sealed, or not, if not. So I appreciate the exercise. At first I found it a bit tedious and painful because it took a lot of time to go through all of it. But the defendants put it into binders that I found were really pretty helpful, and I think it is an important exercise to go through. So I agree with the exercise. I know both of you have your zealous advocates for your client. I think you're both effective zealous advocates for your client, and then it rests on me. Do you have anything else you'd like to say?
No, Your Honor.
Okay, so why don't we do this? I see people keep coming and going. Nobody wants to leave, but why don't we take about a 5-7 minute comfort break? Everybody comes back and then we'll get going on. We'll start with confidential filing 1. Now, I say that, but do you all know the same path, the same order? Does the plaintiff?
We got an index, so I don't know exactly what you got. We didn't get the exact thing.
Yes, Your Honor.